Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting at a diverse location within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Massachusetts Appeals Court on this December 29th, 2020. I am Justice Joseph Ditkoff, and I'm the single justice for this case. I'll call the case. It's U.S. Bank National Trust N.A. versus Healy, number 2020 J112. For the record, would the attorney for the bank identify himself?
Judge, good morning. Attorney Lawrence Von Barta for Plaintiff, U.S. Bank.
And Mr. Healy, would you introduce yourself for the record, please?
Yes, sir. Michael Healy.
Thank you both. As you know, back in March 12, 2020, I heard an appeal of the motion to waive the appeal bond, the denial of the motion to waive the appeal bond. I affirmed the denial of the motion to waive the appeal bond, but I vacated the use and occupancy payments, and I remanded to the housing court for a redetermination of them. I have now gotten that redetermination, and the appeal of that redetermination, the use and occupancy, is now before me, and that's what we're hearing today. It's your appeal, Mr. Healy, so why don't you go ahead?
Okay. The trial occurred in two phases, and the first time we appeared, I objected to the attorney testifying, and I was overruled. So the proceedings went on over my objection, and Mr. Von Barta had a affidavit by what was his name? Well, it was by a realtor. I don't have his name right here. Stating what his opinion was of the value of the house.
Mr. Healy, you're talking about Timothy Waldron?
Yeah, that's correct, Timothy Waldron. And so at that point in time, the justice said that we would come back a week later, and which we did. And so Mr. Waldron got up. I had a chance to discuss this with him. I honestly don't feel that it's fair. It states the price of rental properties in other towns. One in this town, far more than what the current property should rent for. Also, I don't feel we should even be discussing this at this point.
Why is that, Mr. Healy?
The original hearing in front of Donna Silvato, Justice Silvato, my right to a jury was waived by her over my objections. I was told that I would have to participate in that hearing at that time. And for this hearing here, I was sent a statement dated December 11th, 2020, enclosed, please find certified copies of the docket entries in the above entitled matter. A copy of the notice of appeals number 28, number 14, number 16, number 26, and number 25, judgment dated November 23rd, number 27. I have gone on to the e-file, and when I bring up the docket number, which I've had multiple attempts, probably about 4 dozen attempts to try and bring that case up, and it always says case not found, whether I use the name, the case number, variations of the case number. Yesterday I was with e-file tech support, and the woman named Mallory, I gave her the number, and she tried to find it. She was unable to find it. It said, yes, well, I can see what you can see on your screen, and although the courts may have it in their system, you are blocked out of it. And I would have to get an order from a judge in order to be able to see either documents that I have filed or documents that Attorney Von Vader or the bank has filed.
Well, the bank has filed a document called Plaintiff's Opposition to Defendant's Second Request for Review by the Appeals Court of the Order Relating to the Appeal Bond. Have you seen that document?
I do not believe so.
It was mailed to you by mail on December 17th at 44 Bernard Street. You haven't received
I
it?
received a packet yesterday, postmarked December 18th. Yesterday at 4 o'clock, when my mailman came by.
Right, you got a chance to read that?
Not completely, and I don't see the documents 28, 14, 16, 26, 25, and 23, and excuse me, and 27 in there.
It's just a six-page pleading.
The packet I received has got at least 30 pages, if not more. They're not numbered, so I don't know. I haven't counted them.
I suspect that's the assembly from the housing court.
I'm sorry. That was what?
I suspect that's the assembly of the record from the housing court, not something that was filed by the bank. The only thing I have from the bank is this opposition. That's 6 pages that I gather you received yesterday.
Okay. I believe I have that here. Plaintiff's opposition to defendant's second request for review by the appeals court.
Right. And
That's the one. Okay.
I received from you a document called Defendant's Motion for Relief. And of course, I received your motion to continue and your motion to participate by phone. Is there anything I'm missing that you wanted to file?
Well, on this document, it refers to the plaintiff, myself, and my son Thomas. I don't believe Thomas should have anything to do with this. This is his childhood home. Before Robin Stoddard was listed, Tom's mom, and she passed away in 2014, so she apparently has been removed. But I honestly believe Thomas should be removed as well. He has nothing to do with this. He did not sign any mortgage payments, rental agreements, or anything else. This has been his home his entire life.
So are there any documents that you want me to see that you have not been able to get to me?
I would like to be able to get everything from the proceedings in the lower court.
I mean, is there something you want me to see? That you want
Well, at one point in time, I believe it was Justice Michaud found my son's testimony after being sworn in uncredible. Basically called my son a liar. My son is not a liar. And if the court feels he's a liar, I don't understand why he has any place in this case.
Can I ask you this? You filed your notice of appeal of the judgment against you back in January. What have you done towards getting that appeal moving? How is the transcript ordering going? What has happened?
With federal court?
No, in state court, you had a judgment against you in December, a year ago, and then you appealed it in January. And this, of course, is an appeal bond to determine whether what you need to post to keep the appeal going. Have you ordered the transcripts from the December trial?
No, that's what I'm saying. I can't get access to anything that has occurred in housing court. Like when I put in the number 2020 J0540, I have access to everything from my side. I don't have access to anything from the bank side. When we were in federal court through the EFC PACER, I had access to all filings in the case. Here, I don't have that access. And I would like access to that so that I can be more precise and so that I can quote what exactly has transpired. And I would like the decision that I referred to, New York Bank Mellon versus Deirdre A. Dutton, under the order, it basically says the defendants is required to pay neither the appeal bond nor periodic use and occupancy payments, according to G.L. 39 subsection 5. No parties have tenancy relationship, and defendant does not owe rent under GL 239 subsection 5. Therefore, forbade the housing court from ordering periodic payments pending appeal. And then I guess subsection 6 is inapplicable because there was no bond at that point in time.
Afraid the SJC.
Apparently the bond is still under appeal.
The SJC has ruled that there is use and occupancy payments in a foreclosure context in Bank of New York Mellon versus King.
I'm not familiar with that case.
In any event, is there anything else that you want to raise about the determination of the use and occupancy payments in the housing court?
Well, yeah, there are, but like I said, I don't have all the paperwork in front of me. And I don't have access to it on the e-file. So I was hoping that I could get an order ordering the lower court to allow me to have access, as well as appeals court allowing me to have access to both sides of the case.
Well, it seems that you have what the bank filed, and I have everything you filed.
But I don't have everything the bank filed.
Well, the only thing the bank filed is this opposition to defendant's second request for review by the appeals court of the order relating the appeal bond that we discussed. That's the only thing I have from the bank.
Right, and it notice it states a copy of number 28, number 14, number 16, number 26, number 25, and number 27. And if I have them, they are not labeled under those numbers, so I have no idea what this is referencing. As well as when I was in court, the lower court, I was handed a packet moments before the trial started, which was as large as this one, and nothing there. There were no page numbers or anything. But apparently, the judge and the bank had set up a numbering system which was not included on my paperwork, and they're just proceeding at lightning space. I'm trying to locate documents and number them to refer to, and I was unable to do so.
Well, it's generally the case that the court, not the bank, numbers documents as they get them. But what I've got is this pleading that you have. That's what I have from the bank. Of course, I've seen the documents from the lower court that I assume you've seen the judge's ruling on the appeal bond that you're appealing. I have that. And of course, the documents that we had the last time we were in court. But I don't think I have anything that I'm looking at that you don't have.
Well, I mean, without being able to have them compiled and numbered, I have a hard time referencing. I have all this material, and Lawrence von Bader included the proceedings from federal court in this packet. And if you, I don't know if you have that, but I believe that was labeled Exhibit E.
Just describe the documents, because I don't have any of these numbers either.
Yeah, and so, exactly, and that's what my problem is. And in order to prepare a proper case, I should have access to this. I mean, I'm appealing the fact that when I objected to Lawrence von Bader testifying, the judge overruled me and then rescheduled it and made Timothy Waldron available the next time. When I was in the lower court earlier, I said, well, I have a witness. And she said, well, if he's not here today, that's it. So I feel that it's biased towards the bank. They're given an opportunity to show up in court without the witness and then present it. When I had done that previously, I was not given the same opportunity.
All right, so let's walk through that. You asked for a continuance at the time of the hearing in November 10th. Is that what happened, or is that not what happened?
I believe that was before November 10th. I believe that was at the first hearing, which would have been under Donna T. Salvado, and she basically said, we are proceeding, and she waived my right to a jury, and she gave me 15 minutes to look over a packet that I had just been handed, as well as some 30 or 40 documents I had from federal court out of a total of about 70. I tried to narrow them down before getting in there. It was just like, she had X amount of cases to get through that day, and that's what she was going to do, regardless of what I needed for time to prepare.
Which day is this? Is this October 29th or November 10th?
Like I said, I don't have all of this stuff right in front of me, so I can't quote dates.
Well, there were two.
But I believe it was the earlier date, because I believe the second appearance was before Justice Michaud.
All right. So on the first date, you were given documents. You didn't have time to look at them, but there was a continuance to November 10th. And what happened on November 10th? That was a problem.
As I said, without having them right in front of me, I can't remember all the facts, and that's why I would like them so that I can do this in an orderly fashion. And I was assured by e-file tech support, Mallory, who I opened my screen to so that she could help me accomplish these filings. I am aware that you only got them yesterday, but I did make several attempts, over a dozen attempts, to file it on Christmas Eve, and you were kind enough to postpone this till today. And I figured I could go on e-file and get all of this stuff. I was not able to get through the tech support until yesterday morning. And she said, yeah, no, there's on the docket number from the lower courts, there's no way that you could have possibly seen anything that was filed by yourself or the other side. Every time I talked to the clerks at housing court, they assured me that the trial was in e-file and that I was putting the number in incorrectly. And she tried every combination she could think of, and she could not bring up the case. It said the same thing to her, that the case was not found, whether she used my name or the docket number. And I understand today we have a new docket number, which is 2020-J-112.
I'm sorry, that was my error. That is what I said, but I was reading the old docket number from our earlier.
So are we still on 0540?
Yes, we are. That was my error. I apologize.
Okay. Well, so I mean, you can see my confusion. I don't know how many of these errors were made in the paperwork previous, and without being able to get them together, review them as a unit. I don't sound very professional, to say the least.
I'm not seeing any documents in the housing court computer system after October 23rd, other than your notice of appeal.
Well, I'm not able to see any of them.
Yeah, I'm suggesting
Period.
any except for the one you filed in the computer system.
When I use the docket number or my name and U.S. Bank to locate the case, it is not located. And I went over this with the tech Mallory yesterday, my second call to tech support. First time I talked with John. And she said, is there anything I can help you with, anything else I can help you with? And I explained to her the trouble I was having with e-file in the lower court, and so she offered to try for me. She tried every combination she could think of and was unable to obtain any information from either side. So she recommended that I make a motion to the court to request that they open access to me so that I can refer to this information.
Is there anything else you want to tell me about why the order is erroneous?
Excuse me?
Is there anything else you want to tell me about why the use and occupancy order is erroneous, is an error?
Well, I don't believe that the pricing, if I were to concede, which I don't intend on doing, I don't feel that the sole opinion of Tim Waldron, and he also mentioned in his statement relying upon his partner, who did not submit an affidavit and was not present for me to question. Yet the lower court relied on that to come to the decision. And in the order, it did state that they were relying on this partner of Tim Waldron's who made no statement, and the only statement made was Tim's statement in regards to what his partner told him, which shouldn't be allowed under hearsay.
Anything else? Do you have anything else?
Like I said, yes, there are other issues, but not having the material right in front of me is kind of hard to refer to. You know, the ideal situation would be to have, and what would be fair and just would be to have access to all the documents and transcripts.
Well, are there transcripts? Have you ordered any transcripts?
I'm not aware that there are any transcripts, but if they do exist, I should have access to them.
Healy, did you order any transcripts?
I have not ordered them from housing court. When I ordered them from federal court, I was just ignored, which barred me from filing for an appeal, because the law states that without them, I'm not entitled to file for an appeal, which is why I don't believe we should even be at this stage at this point in time. Another one of my many objections.
Why haven't you ordered any transcripts?
I was focusing on trying to get together all the material here. I guess that was an oversight on my part.
All right. Thank you, Mr. Healy. I'll hear from the attorney for the bank now, Mr. Lombardo.
Thank you, Judge. Judge, I'm not really too sure what to say in terms of Mr. Healy's claims for confusion with not receiving documents. What I can say is this appears to be somewhat of a common theme or ploy used by Mr. Healy to create some issues or suggest that some organizational issues exist, which really only appear to exist for him. I've never had any issues in terms of looking up things on the court's document with the housing court. Another example is during the last hearing that we had in the housing court, Mr. Healy again complained of not receiving a memo submitted by the plaintiff, which was mailed to the same address, which the court also had a copy of, in which we paused the hearing for, so that I could email him a copy of the memorandums, which he then in fact did have. So I'm not really sure what to say in terms of Mr. Healy not having information that he believes he's entitled to. His testimony is that he's done nothing to advance the appeal in terms of ordering any transcripts or taking any other steps. So I believe there might be some attempt of Mr. Healy to manufacture issues which really do not exist. As far as the substance of today's hearing, as this court mentioned in the very beginning, this is now very limited to the issue of the fair market value analysis of what the rental value would be of the underlying property. And we did have a de novo hearing in November with the housing court where an expert witness, Mr. Waldron, was presented. He gave testimony. He was examined by myself. He was examined by the court. He had submitted an affidavit. Mr. Healy was present. He had the opportunity to examine Mr. Waldron as well. And the evidence determined that the fair market rental.
Just a second. Did he cross-examine Mr. Waldron?
I believe he had the opportunity to. I can't say that he asked many questions. I don't recall off the top of my head. He may have asked a question or two, but I honestly can't say. I can't really speak as to the length of any examination given by Mr. Healy. But all parties were present. no rebuttal testimony, no rebuttal evidence was produced whatsoever. Nothing was ever filed to suggest that the market value opined by the plaintiff's expert was somehow inaccurate. And ultimately, the judge adopted the expert's findings that the rental value was $1,600 per month, which allowed the court to calculate the judgment awarded in this matter of $23,557.20 plus costs. So I didn't hear then, and I'm not hearing now, any arguments of substance as to why this real estate expert's opinions should not be valued. Again, this was conducted via an evidentiary hearing back this fall in November, and I'm not hearing anything that should change this court's opinion, and nothing apparently changed the lower court's opinion as well, which is what was stated by Judge Michaud in his findings. Again, while it was found that the defendants may be indigent, there's certainly no non-frivolous defenses here, and now we have a fair market value of the property based on evidence.
Let me ask you a few questions. Mr. Healy suggests that Mr. Waldron relied on what his partner told him. Is this the case?
Mr. Waldron's affidavit speaks to how he arrived at his conclusion, and it states how he himself is specifically familiar with the underlying property, which is known as 44 Bernard Street. He and his company were contracted to inspect the property multiple times, as this is now owned by the plaintiff following the foreclosure in September of 2019. He'd been to the property approximately 3 times. He's inspected the property, and apparently he had arrived at this market analysis by looking at comparable properties on the Cape. And Mr. Waldron did testify to how rental properties on the Cape are or can be challenging, I guess, in terms of determining their value, where there are not really a lot of comparable properties or full year rental properties or something to that effect. And I believe he did use some information that his business had, which some may have been his business partners. So he was able to gather some information to allow him to figure out what some comparable property values were. And those are the properties that are listed on the the third page of his affidavit. So I don't think it's accurate at all to say that he purely relied on someone else's statements. He, from my recollection and from his affidavit, performed his own analysis, and he gathered that information from a variety of sources.
Did he say what the sources were?
Sources from, I guess, information that his company had. It may have been information that one of his business partners had shared with him. So I guess within his, his working knowledge as a real estate agent, I guess his practice, his office has some information, and he was also able to gain some information from one of his partners.
I assume you have not yourself ordered any transcripts?
No.
Can you walk me through this continuance on October 29th?
Generally speaking, the continuance was suggested by the court and agreed to by the parties, where initially we had submitted our motion for, I guess, for the appeal bond to be waived. And at that time, we did not have a lot of, I guess, time to schedule Mr. Waldron to appear for that hearing, because this matter had laid dormant for several months following the COVID-19 pandemic. And at the time of the hearing, we were able to secure his affidavit, but not his physical appearance. So we had requested and spoken with the court where if the court felt it necessary for us to present Mr. Waldron to testify, we would need a little more time. And that's why we were granted a little more time until November 10th, which is when the evidentiary hearing via Zoom occurred.
Finally, do you have any idea why the order is nunc-pro-tunc to February 7th, or even what effect that has?
Well, we didn't really speak about the court's order at the hearing. It was taken under advisement, and we didn't receive it until some time after. My impression is that the judge, relying on his prior findings as to some of the other aspects of the case, that Healy's are in fact indigent and have no non-frivolous defenses, allow his current judgment to relate back to that original judgment in the lower court. So this de novo evidentiary hearing in November was a little more discreet in the sense that it was purely focused on the fair market value of the property, and that value then factored into the court's calculations, which I guess non-pro-tunc went back to February 7th, 2020.
Anything else you want to tell me?
Nothing else further, Judge. I'll rely on my papers, and again, I think we've covered everything here, and I appreciate your time in listening to this matter again, but I have nothing further.
Thank you. Ms. G.L.c, I have one question for you, and then I'll give you 2 minutes to respond to anything you'd like to that the bank's attorney said. My one question is, did you move to continue the November 10th hearing at that hearing? Mr. Healy?
Yes.
At the second hearing, the November 10th hearing, did you ask to continue it? Did you move for the judge to continue it or to delay it?
No, sir. The judge took that upon himself.
All right. Well, I will give you 2 minutes. You don't have to take them if you want to respond to anything Attorney Von Barta just said.
Well, yeah, as far as apparently they claim that they own it from the date of the auction, yet they claimed that they owned it before the auction, put it up for auction, and then bought it back themselves. The witness that I wanted to present in the lower court at the first hearing attended that auction with a check. He was able to qualify to bid on the house. He, after the auction took place, told me this is like no auction I've ever been to before, and he owns several rental properties, and a couple that he has bought at auction. And he goes, it wasn't an auction. And it's my understanding at auction is when they became the owner. Yet they presented no proof that they qualified to present. They didn't show a canceled check for the purchase or anything else. And the documents that I can find, which I never had a chance to present in federal court, state that the properties were bought in a bundle at about 5 cents on the dollar. And so apparently they owned it, but they didn't own it, but they auctioned it, so they owned it. This doesn't make any sense to me why you would own something at $10,000, put it up for auction, and buy it back for $253,000 unless you were trying to doctor paperwork.
With that was 2 minutes. So we'll have to leave it there. I'll take this under advisement. I'll have a decision fairly soon. I'd like to thank both of you, Mr. Healy and Attorney Von Barta. I'd also like to thank our clerk and our incredible staff that's allowed us to continue hearing cases, even though everything has to be remote. It's really been incredible what they've managed to put together in such short time and allow us to continue the business of the appeals court. And with that, we will stand adjourned. Thank you both.
Thank you, Judge.